Imagine you're just sitting in your living room. It's a quiet Tuesday evening. Maybe you're having a cup of coffee.
Sounds pretty nice, honestly.
It is nice.
Yeah.
But suddenly, without any warning, without a single knock, the front door of your house is just kicked completely off its hinges.
Oh, wow. Okay.
Yeah, armed police officers just swarm into your living room. And they do have a search warrant, but they completely ignored the constitutional requirement to knock and announce their presence.
Right, the old knock and announce rule.
Exactly. So they search the place, and they find illegal drugs. Now, if you are listening to this and you're studying for the multi-state bar examination, the MBE, your initial instinct is probably that those drugs are getting thrown out of court.
Because the police broke the rules, so they should lose the evidence?
That's the logical assumption. But surprisingly, that is absolutely incorrect. The evidence comes in.
Which is a reality that completely trips up law students and seasoned attorneys alike. I mean, the legal landscape we're navigating today is just filled with these counterintuitive traps.
It really is.
It's incredibly easy to look at a constitutional violation and just assume the remedy is the suppression of evidence. But the Supreme Court has built this highly complex, highly specific set of doctrines that dictate exactly when the exclusionary rule applies.
And when it doesn't, which is exactly why we're doing this today. Welcome to this custom deep dive. We are talking directly to you, the listener, as you gear up for the MBE.
It's a tough exam, but we've got you covered.
Our mission today is to decode the incredibly dense legal text of Fourth Amendment principles of search, seizure, and exclusionary rules. We are stripping away all that academic fluff.
Right, strictly focusing on the mechanics of the law. We're going to explore not just what the rules are, but why the courts actually created them.
Because, understanding the underlying rationale is really the only way you'll survive those trick questions the bar examiners love to throw at you.
Oh, they absolutely love this area of constitutional law. It requires you to hold multiple competing concepts in your head simultaneously.
Yeah, you have to evaluate the police's actions, the suspect's expectation of privacy, the scope of the search, and the ultimate remedy, often all in a single, multiple-choice fact pattern.
It's a lot to juggle.
To set the stage for all of this, I think it helps to visualize the Fourth Amendment as like the ultimate bouncer standing at the velvet rope of your personal privacy.
I like that analogy.
You've got your home, your car, your pockets, your digital data. It's the VIP lounge of your life. And the Fourth Amendment is standing right at that rope, arms crossed, stopping unreasonable governmental intrusions.
So if the police want to get past that velvet rope, they can't just flash their badge. They need to show the bouncer the right credentials.
Exactly. And I think that framework perfectly sets up the baseline dichotomy of our source material. The ultimate VIP pass is a valid search warrant.
But the law recognizes that the real world is messy. So on one side, we have the rigorous rules for getting and executing a valid warrant. And on the other side, we have a very specific list of exceptions.
Right. Situations where the police do not need to go to a judge to get past the rope. Because sometimes the VIP club is on fire,
Or someone inside is destroying the club and the bouncer just has to let the authorities in to handle the emergency.
Let's start with the gold standard, though. We need to talk about the anatomy of a valid search warrant. Because the MBE loves to present a warrant that looks perfectly fine on the surface, but it has a fatal flaw buried in the text.
They really do. According to the doctrine, a valid warrant requires 3 non-negotiable elements. First, it must be issued by a neutral and detached magistrate.
Okay, that's the one.
Second, it must be supported by an oath or affidavit establishing probable cause. And third, it has to describe with particularity the places to be searched and the items to be seized.
Let's break those down, starting with the neutral magistrate requirement. Because the examiners will occasionally test the boundaries of what neutral and detached actually means.
Right. It basically means the judge can't have a financial stake in issuing the warrant, and they cannot actively participate in the police investigation.
So if the magistrate is literally riding in the back of the police cruiser, pointing out houses to search, that completely invalidates the warrant. The bouncer cannot be high-fiving the cops, basically.
Exactly. The judge has to act as an independent safeguard between the citizen and the state. But the area where law students really get bogged down is that second requirement, probable cause.
And here is where the MBE loves to blur the lines, specifically with informants. I mean, we all know probable cause is more than just a hunch, right?
Right. It's more than reasonable suspicion.
But it absolutely does not require absolute certainty. It's just a fair probability. But how does a judge evaluate that fair probability when the info isn't coming from a cop's own eyes, but from some shadowy, anonymous informant.
This is a classic exam scenario, and to understand it, we have to look at the landmark case, Illinois v. Gates.
Oh, I was reading the background on Gates, and the facts are just fascinating.
Go for it. Lay it out.
So, the police department received an anonymous handwritten letter. It said that a couple, Lance and Susan Gates, were selling drugs out of their home in Illinois. And the letter was incredibly specific.
Right, the logistics of the trip.
Yeah. It said Susan would drive their car down to Florida, leave it there, and fly back. Then Lance would fly down, pick up the car, which would be loaded with drugs, and drive it back.
Now, before Gates, the courts used a very rigid, two-pronged test for informant tips. They required the police to prove both the informant's basis of knowledge, like how they knew the info, and their overall reliability.
And under that old, rigid test, that anonymous letter was completely useless.
Exactly. The police had no idea who wrote it, so they couldn't establish a track record of reliability. It could have been a rival drug dealer or just a prankster.
But the police didn't just take the letter to a judge. They actually investigated. They watched Lance and Susan, and they saw them do exactly what the letter predicted.
Susan drove down, Lance flew down, they met at a motel, and Lance started driving the car back north.
So the cops take all this corroboration to the judge, get a warrant, search the car in Illinois, and find hundreds of pounds of marijuana. Lance and Susan's lawyers naturally argued the warrant was invalid because the tip failed that rigid test.
Which brings us to the actual holding of Illinois v. Gates, which you absolutely need to know for the bar. The Supreme Court threw out that rigid two-pronged test and replaced it with the totality of the circumstances test.
Totality of the circumstance. That phrase comes up so much.
It does. The court said a magistrate shouldn't be handcuffed by rigid formulas. An anonymous tip, standing alone, is rarely enough for probable cause.
But if the police can independently corroborate the innocent details of the tip, like those specific travel arrangements, it lends heavy credibility to the unverified allegations.
The logic being, if the informant was right about the incredibly specific, bizarre travel logistics, there is a fair probability they're also right about the drugs in the trunk.
So for the MBE, if you see a fact pattern where an officer gets an anonymous tip, the question you must ask yourself is, did the officer corroborate enough predictive details to give the magistrate a substantial basis for a warrant?
If yes, the probable cause holds. It's that simple.
Okay, now let's look at this from the defense attorney's side. Let's say the police get the warrant, execute the search, find the evidence, and arrest the guy.
Standard procedure.
But then the defendant is looking at the affidavit, and they realize the police officer actually lied. Not an informant, but the sworn police officer. How do you attack a warrant that looks facially valid?
This is governed by the Franks rule from Franks v. Delaware. And the bar examiners test this by playing with the level of intent.
Right, because you can't just waltz into court and say the magistrate made a bad call.
No, and you can't invalidate a warrant just because the cop made a sloppy typo or a careless mistake. To challenge it, the defendant demands a Franks hearing, and they carry the burden of proof.
The source material outlines two massive hurdles here. First, the defendant must prove, by a preponderance of the evidence, that the officer included false statements knowingly, intentionally, or with reckless disregard for the truth.
The distinction between negligence and recklessness is vital. If an officer writes down that the suspect's house is white when it's actually light gray, that's just an innocent mistake. The warrant survives.
But if they swear under oath that they personally saw the suspect carry drugs inside, when in reality the officer was on vacation in another state, that's an intentional lie.
Exactly. But even if you prove the officer lied, that isn't the end of the inquiry. There is a second hurdle, and this is the load-bearing pillar of the doctrine.
The severance test.
Yes. The defendant must prove that those specific false statements were necessary to the magistrate's finding of probable cause.
So imagine taking a thick black marker and crossing out only the lies in the affidavit. You physically redact the falsehoods.
Then you look at whatever truthful information is left behind. Does the remaining truthful information still amount to probable cause?
Let's say the affidavit had 5 pages of solid corroborated evidence and just one paragraph containing a reckless lie.
If you cross out that one paragraph, the judge probably still would have issued the warrant based on the 5 solid pages.
Therefore, under the Franks rule, the warrant remains completely valid and the evidence comes in. The lie wasn't necessary.
But if the lie was the only thing tying the suspect to the crime and crossing it out leaves the affidavit empty, then the warrant is invalid and the evidence is suppressed.
The examiners will give you a scenario where an officer absolutely lies, but the lie is mathematically irrelevant to the probable cause. Do not fall for the trap of throwing out the evidence just because the officer was a bad actor.
Apply that severance test every time.
Moving to another fascinating aspect of warrants, anticipatory warrants. When I first read about this, it sounded like a total legal paradox.
How so?
Well, the Fourth Amendment says warrants must be based on probable cause that evidence is in a specific location. But anticipatory warrants let police get a warrant to search a house before the drugs are even there. It's like an Amazon pre-order for a search.
That's a great way to put it. The Supreme Court addressed this directly in United States v. Grubbs. And the facts in Grubbs perfectly illustrate the mechanism.
Right. They intercepted a package of illegal material, a videotape with child pornography addressed to Grubbs.
And the police didn't want to just arrest him at the post office. They wanted to search his home for a larger collection. But at that exact moment, there was no probable cause that illegal material was currently inside his house.
Because the tape is sitting on a table at the police station.
Exactly. So they went to a magistrate and asked for an anticipatory warrant. They argued there was a fair probability the contraband would be at the house, but only after a specific event occurred.
The triggering condition.
Yes. The rule is that an anticipatory warrant is perfectly valid if two conditions are met. First, if the triggering condition occurs, there must be a fair probability that contraband will be found.
And second,
there must be probable cause to believe that the triggering condition will actually occur.
so in Grubbs, they did a controlled delivery. An undercover cop posed as a delivery driver. The triggering condition was Grubbs taking physical possession of the package and bringing it inside his home.
The moment he walked through his front door with that tape, the condition was met, the warrant activated instantly, and the police raided the house.
For exam purposes, pay really close attention to the triggering condition in the fact pattern, because if the police execute the search before the triggering condition occurs, the search is warrantless.
And presumptively unreasonable. The warrant only comes to life the second the condition is satisfied.
Okay, let's circle back to that incredibly jarring scenario we opened the deep dive with, the knock and announce rule. The police have a valid warrant, they walk up and just kick the door down.
The text outlines the underlying rationale for the requirement. It isn't just about politeness. It's to prevent violence. A homeowner might shoot an intruder thinking it's a home invasion.
And to prevent the destruction of property, like blowing door frames to splinters. Plus, protecting human dignity, giving people a moment to put on a robe before opening the door.
But the law recognizes that sometimes announcing your presence is dangerous or futile.
Right, the exigent circumstances exception. Under Kerr v. California, if the police have reasonable suspicion that knocking would be dangerous or would allow suspects to flush drugs down a toilet, they can just force entry.
But the real MBE trap isn't the exception, it's the remedy for the violation. Let's look at Hudson v. Michigan.
This is the one that blows my mind.
In Hudson, the police had a valid warrant for drugs and a gun. They arrived, announced their presence, but only waited 3 to 5 seconds before turning the knob and entering.
Which the state conceded was not enough time to satisfy the rule. They violated the Fourth Amendment. So the defense argued the drugs and gun should be suppressed as fruit of the poisonous tree.
And this is where the Supreme Court drew a massive line in the sand. The court held that a violation of the knock-and-announce rule does not require the suppression of all evidence found in the search.
It's so counterintuitive. If they violate the Constitution to get inside, why do they keep the evidence?
Because you have to separate the manner of entry from the authority to search. The police already possessed a valid search warrant. That warrant gave them the absolute right to enter and search.
Ah, so the drugs and the gun were going to be discovered regardless of whether the police waited 5 seconds or 5 minutes at the front door.
Exactly. The interests violated by the sudden entry protecting doors, dignity preventing surprise violence, have absolutely nothing to do with the seizure of the evidence.
So applying the massive hammer of the exclusionary rule would just be disproportionate.
Right. The defendant's remedy might be a civil lawsuit for a broken door or emotional distress, but it doesn't buy them a get-out-of-jail-free card for the drugs legally found pursuant to the warrant.
So if I'm staring at an MBE question, and the fact pattern goes out of its way to emphasize that the cops completely ignored the knock-and-announce rule without justification, but they had a valid warrant, my instinct must be that the evidence is admissible.
Do not let the examiner's vivid description of a splintered door trick you. The warrant is the golden ticket.
Okay, that covers the rigorous world of warrants. But let's be real, the justice system does not always move at the speed of a magistrate's signature. Police operate in a chaotic environment.
They don't always have time to type up an affidavit and find a judge. Which brings us to the heavyweights of the Fourth Amendment, the warrantless search exceptions.
And we begin with arguably the most commonly tested exception, search incident to a lawful arrest, or SILA.
And the core concept here is that a lawful custodial arrest fundamentally changes the suspect's expectation of privacy while creating immediate dangers for the arresting officer.
To understand the boundaries, we have to look at Chimel v. California. The facts at Chimel show us what SILA used to look like before the Supreme Court reined it in.
The police arrived at Ted Chimel's house with an arrest warrant for a coin shop burglary. They arrested him in his living room. But they didn't stop there.
No, they systematically searched his entire three-bedroom house, the attic, the garage, digging through small drawers, claiming it was incident to his arrest. And they found stolen coins.
And the Supreme Court looked at that and said, absolutely not. The court established that a search incident to arrest is strictly justified by two specific needs: officer safety and the preservation of evidence.
The logic is simple. When you arrest someone, they might have a hidden weapon to attack the officer, or evidence they could quickly swallow or destroy.
Therefore, the court in Chimel established the wingspan rule. Upon a lawful arrest, police may automatically search the arrestee's person, their pockets, and the area within their immediate control.
I always picture the arrestee as a toddler sitting in a shopping cart at the grocery store.
That's a vivid image.
If that toddler can reach out their little arms and grab a candy bar off the checkout shelf, that shelf is within their wingspan. If the police arrest you in your kitchen, they can search the kitchen drawer you're leaning against.
But they cannot walk down the hall and search the guest bedroom. The guest bedroom is outside the wingspan.
The spatial limitation is critical, but so is the temporal limitation, right?
Yes. A SILA search must be contemporaneous in time and place with the arrest. If the police arrest a suspect, lock them in a holding cell at the station, and then an hour later decide to drive back and search the kitchen drawer.
That is no longer a search incident to arrest. The suspect is in a cell. They can't reach the drawer. The emergency has evaporated.
Exactly. Now let's bring this into the 21st century, because the MBE loves testing modern technology. Let's say I'm arrested on the street. The police search my pockets under SILA, which is legal.
And they pull out your smartphone. It was physically in your pocket, unequivocally within your wingspan. Can the arresting officer swipe open your phone and start reading your text messages under SILA?
They absolutely cannot. And this is a massive development in Fourth Amendment jurisprudence from the case Riley v. California.
I remember reading the Riley opinion. Chief Justice Roberts basically said that comparing a modern smartphone to a physical item in a pocket, like a wallet, is like saying a ride on horseback is indistinguishable from a flight to the moon.
It's a brilliant quote. The court's reasoning goes back to the two justifications for SILA: officer safety and preventing destruction of evidence.
Let's apply those to a cell phone. Can the digital data inside a phone be used as a weapon to stab an officer? No.
Once the physical phone is secured in the officer's hand, can the arrestee reach into the digital ether and delete the files? Also no.
Because the immediate physical threats are neutralized the moment the officer takes possession of the device, the SILA justifications vanish.
Furthermore, the court recognized the unprecedented privacy interests implicated by smartphones. A phone isn't just a container. It's a portal to a person's entire life: medical records, banking, location data.
So allowing police to freely rummage through that data just because of a traffic arrest would be a massive expansion of police power.
Therefore, the rule is hard and fast. Police may physically seize the phone during a SILA search to ensure it isn't a disguised weapon, but to search the digital contents inside, they must go get a warrant.
Okay, adding to that context, what happens when the arrest doesn't happen on the street, but inside a home? We established with Chimel that they can't search the whole house, but surely they don't have to just put blinders on.
This brings us to the concept of the protective sweep. The governing case here is Maryland v. Bowie.
The facts there are really important, right?
Critical. The police had an arrest warrant for Bowie for an armed robbery committed by two men. They entered Bowie's house and arrested him as he emerged from the basement.
After he was handcuffed, an officer went down into the basement, in case there was someone else down there, and they found a red running suit in plain view that tied Dewey to the robbery.
Bowie argued that once he was handcuffed in the living room, the arrest was over, and going into the basement violated the Chimel wingspan rule.
But the Supreme Court carved out a limited exception for officer safety in confined spaces.
The court held that incident to an in-home arrest. Police can automatically, without any probable cause or reasonable suspicion, look in closets and other spaces immediately adjoining the place of arrest from which an attack could be launched.
We're not looking for evidence here. We're looking for Confederates, the second armed robber hiding in the hallway closet.
Precisely. But notice the limitation. It only applies to spaces immediately adjoining the place of arrest.
If the police want to sweep beyond those immediately adjoining spaces, like going down to the basement when the arrest happened on the second floor, they need more.
Yes, they must have articulable facts that warrant a reasonably prudent officer in believing that the area to be swept harbors an individual posing a danger.
So because the robbery in Bowie was committed by two men, it was highly reasonable for the police to suspect the second armed man might be hiding in the basement. They had the reasonable suspicion needed to do the broader sweep.
And remember the scope of the sweep. It is a cursory visual inspection of places where a person might be hiding. You can look under a bed or inside a closet. You cannot open a shoebox or a desk drawer.
Because a person can't hide in a desk drawer. If you see an MBE question where an officer finds drugs inside a jewelry box during a protective sweep, that search is illegal.
Spot on. Now let's shift the dynamic. Everything we've discussed so far, Scylla sweeps, requires a lawful custodial arrest.
But what if the police don't have enough evidence to arrest you, but they strongly suspect you are up to no good? Do they just walk away?
This introduces the cornerstone of modern street policing. The Terry stop, or stop and frisk, birthed in the landmark 1968 case, Terry v. Ohio.
Before Terry, the law only recognized two states of being. Right. You were either completely free to go, or you were under full custodial arrest requiring probable cause. There was no middle ground.
The facts of Terry read like a noir novel. A plainclothes detective named McFadden is patrolling downtown Cleveland. He watches two men, Terry and Chilton, standing on a street corner.
One man walks down the street, peers into a specific store window, turns around, looks again, and returns. Then the other man does the exact same routine, over a dozen times, pacing and staring, conferring with a third man.
Detective McFadden concludes they are casing the store for a daylight armed robbery, but he doesn't have probable cause to arrest them yet. Window shopping is perfectly legal.
But he fears they have guns. So he approaches them, spins Terry around, and pats down the outside of his overcoat. He feels a pistol, reaches in, and removes it.
Terry's lawyers argued that because McFadden didn't have probable cause for an arrest, touching Terry at all was an unconstitutional search and seizure.
And the Supreme Court responded by creating that crucial middle ground. The court recognized that police need a graduated response. A stop is a brief, temporary investigative detention.
It is a seizure under the Fourth Amendment, but because it's significantly less intrusive than a full arrest, it requires a lower standard of proof. A police officer may stop a person if they have reasonable suspicion based on objective, articulable facts.
Articulable facts being the magic phrase. An officer can't just say, I had a gut feeling he was a bad guy. They have to point to specific behaviors, like the highly coordinated, repetitive pacing in Terry.
The bar examiners will test the boundaries of reasonable suspicion heavily. Consider Illinois v. Wardlow.
Oh, the flight example.
Right. An officer is driving through a high-crime area. A man is standing next to a building holding an opaque bag. When he makes eye contact with the police cruiser, he immediately sprints away.
Now, just being in a high-crime area isn't a crime.
Yeah.
And you generally have the right to ignore the police and walk away.
True. The Supreme Court said mere presence in a high-crime neighborhood is not enough, and simply refusing to cooperate isn't enough.
But unprovoked headlong flight is different. It's the consummate act of evasion. When you combine the high-crime area with sudden, unprovoked flight at the sight of police, the totality of the circumstances crosses the threshold into reasonable suspicion.
The police can legally chase that person down and stop them to investigate.
Okay, so that covers the stop. The officer has frozen the situation to ask questions. But what about the frisk? Does an officer automatically get to search your pockets every time they stop you?
Absolutely not. This is a vital distinction. A stop does not guarantee a frisk. To elevate the encounter to a frisk, the officer must have a separate, distinct, reasonable suspicion that the person is armed and currently dangerous.
And the scope of the frisk is incredibly narrow. It is not a fishing expedition for evidence. The sole legal justification is the protection of the police officer.
Therefore, it is strictly limited to a careful pat-down of the outer clothing to feel for weapons.
Which brings up the critical distinction of the plain field doctrine, established in Minnesota v. Dickerson. What happens if an officer is legally patting someone down for a weapon and their hand sweeps over a lump that clearly isn't a gun, but feels suspiciously like a baggie of crack cocaine?
In the Dickerson case, the officer felt a small lump, and he squeezed it, slid it between his fingers, and manipulated it to figure out what it was. And the Supreme Court said that went too far.
Right, because the Terry frisk is for weapons only. Once the officer realized the lump wasn't a weapon, the justification for the search ended.
By squeezing and manipulating the lump to determine if it was drugs, the officer conducted a new warrantless search without probable cause.
But the court did leave a window open. They said that if an officer conducts a lawful, flat-handed pat-down and feels an object whose contour or mass makes its identity as illegal contraband immediately apparent, they can seize it.
If the officer pats your pocket and immediately feels the distinct shape of a crack pipe, they don't have to ignore it. The tactile discovery generates the probable cause to pull it out.
So for the MVE, if the fact pattern says the officer manipulated, squeezed, or prodded a soft object to figure out what it was, the evidence is out. If it was immediately apparent on the first touch, the evidence is in.
Exactly. Let's round out the emergency exceptions with exigent circumstances. These are the no time for a warrant scenarios, evaluated under a totality of the circumstances test.
We have hot pursuit, destruction of evidence, and emergency aid. Let's start with hot pursuit. If the cops are chasing a suspect and the suspect runs into a house, they don't have to sit on the porch and wait for a judge. They can bust the door down.
But the MBE will test the limits of that pursuit. The Supreme Court recently clarified this in Lange v. California. The traditional rule was that hot pursuit applies to fleeing felons. But what if the police are pursuing someone for a minor misdemeanor?
Like playing music too loud or a minor traffic violation.
In Lange, a man was listening to loud music and honking his horn. An officer followed him to his driveway and turned on his lights. Lange ignored the officer, drove into his garage, and the garage door started to close.
The officer stuck his foot under the door to force it back up and entered the garage without a warrant.
The Supreme Court ruled that the pursuit of a fleeing misdemeanor suspect does not categorically justify a warrantless entry into a home. The Fourth Amendment treats the home as the ultimate sanctuary.
Bypassing that sanctuary requires a genuine emergency. While fleeing a felony almost always presents an emergency, the suspect might be dangerous, fleeing a minor noise complaint does not.
In misdemeanor cases, courts must look at the specific facts. If there is no immediate danger or risk of evidence destruction, the police must wait outside and get a warrant.
Another major exigency is emergency aid. This is where police enter a home without a warrant because they believe someone is in danger. The key case is Brigham City v. Stewart.
Officers responded to a loud party complaint at 3 a.m. When they arrived, they looked through a window and saw a chaotic fight inside. 4 adults were restraining a juvenile, and the juvenile punched one of the adults in the face, causing them to spit blood.
The officers opened the door, entered, and announced their presence to break up the fight.
The defendants tried to suppress the evidence of the underage drinking party by arguing that the officers' real subjective motive for entering was just to bust the party and make arrests.
Not to provide medical aid for a minor bloody lip.
But the Supreme Court unanimously rejected that argument. The Fourth Amendment uses an objective reasonableness standard. The subjective secret intent of the police officer is completely irrelevant.
It doesn't matter if the officer hates the homeowner and is actively looking for an excuse to snoop. The only legal question is, would a reasonable officer believe that someone inside needed emergency assistance?
Seeing a violent brawl where someone is punched in the face objectively justifies entering to restore order and provide aid. The entry was valid.
Okay, before we leave the realm of persons and step into vehicles, I want to highlight one specific MBE trap that connects to SILA. We established that if the police arrest you, they can search you. But what if they just write you a ticket?
You're referring to Knowles v. Iowa, a classic trick question. An officer pulled Knowles over for speeding. Under state law, the officer had the authority to arrest Knowles, but chose to issue a written citation instead.
After handing him the ticket, the officer searched the entire car, finding marijuana, and tried to justify it as a search incident to a citation.
And the Supreme Court unanimously struck it down. The rationale for SILA is based on the prolonged exposure and danger of taking a suspect into custody and transporting them.
Issuing a traffic ticket is a brief encounter. Once the ticket is written, the suspect is free to drive away. There's no major threat to officer safety and absolutely no risk the suspect will destroy evidence of speeding.
Therefore, if there is no custodial arrest, there is no SILA search, period.
Which serves as the perfect transition. Because if the walls of a home are the ultimate constitutional boundary, what happens when we step outside and get into a vehicle?
The expectation of privacy fundamentally changes.
The Fourth Amendment treats your car very differently than your house. And mastering the rules surrounding vehicles is probably the highest yield studying you can do for the MBE.
The examiners will relentlessly try to trick you by conflating two entirely separate legal doctrines: searching a car under SILA and searching a car under the automobile exception. We need to untangle these completely.
Let's start by applying what we just learned about SILA to a vehicle. The reigning case is Arizona v. Gant.
Before Ghent, if police arrested someone who had recently been in a car, they automatically searched the entire passenger compartment as a search incident to arrest.
The facts of Gant highlight how absurd this had become. Rodney Gant was arrested for driving with a suspended license. He was handcuffed and locked in the back of a police patrol car.
After he was completely secured, the police went back and searched his car, finding a gun and cocaine in a jacket pocket on the back seat.
The Supreme Court recognized this, completely abandoned the Schimmel rationale. If SILA is justified by the danger of a suspect reaching for a weapon or destroying evidence, how could a man handcuffed inside a metal cage pose a threat to a jacket inside his locked car?
He couldn't. So the court laid down a new, strict two-part test for searching a vehicle incident to arrest. The police can only search the passenger compartment under SILA if they meet one of two prongs.
Prong 1 is the traditional wingspan test. The arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search.
If the suspect is standing right next to the open car door, not handcuffed, and could realistically dive back in to grab a gun, the police can search that area.
But if they're locked in the squad car, Prong 1 is dead. So the police have to rely on Prong 2. What's that?
Prong 2 states the police can search the passenger compartment if it is reasonable to believe that evidence relevant to the offense of arrest might be found in the vehicle.
And this is where the specific crime matters immensely. Let's apply Prong 2 to Rodney Gant. He was arrested for a suspended license. Is it reasonable for police to think they'll find evidence of a suspended license in a jacket pocket?
No. The evidence of that crime is purely administrative. It's in the DMV computer. Therefore, because he was secured, failing Prong 1, and there was no evidence of the crime to be found, failing Prong 2, the search of Gant's car was unconstitutional.
But compare that to a different scenario. Cops pull a driver over, approach the window, and see the driver frantically trying to swallow a baggie of cocaine. They arrest the driver for drug possession, handcuff him, lock him in the cruiser. Can they search the car under SILA?
Let's run the test. Is he unsecured? No, he's in the cruiser. Prong 1 fails. Is it reasonable to believe that evidence of the offense of arrest drug possession might be found in the vehicle?
Absolutely. Drug users often have more drugs hidden in the car. So under Prong 2, the police can search the passenger compartment even though the suspect is locked away.
And note the scope of a vehicle SILA search. It is limited to the passenger compartment and any containers found within it. It does not extend to the trunk of the car.
Okay, now completely wipe SILA from your mind. Put it in a box. We are shifting to an entirely different justification for searching a car. The automobile exception from United States v. Ross. This has nothing to do with whether someone was arrested.
The automobile exception is grounded in two realities. First, cars are inherently mobile. If police leave a car to get a warrant, the evidence will likely be driven away. Second, cars are subject to pervasive government regulation.
Inspections, licensing, transparent windows. Citizens just have a much lower expectation of privacy in a car than in a home. The rule is incredibly powerful. If law enforcement has probable cause to believe a vehicle contains contraband, they do not need a warrant.
They can search the vehicle right there on the side of the road. But the key is the trigger: probable cause of contraband. The bar examiners will try to trick you by giving an officer probable cause for a traffic ticket and then having them search the trunk.
Right, if an officer pulls you over for a broken taillight, they have probable cause that you committed a traffic infraction. They do not have probable cause that your trunk is full of stolen electronics. They cannot search the car.
But let's change the facts. An officer pulls you over for a broken taillight. As they lean down to ask for your license, they smell the overwhelming odor of unburned marijuana billowing out from the back seat.
That changes everything. The smell instantly generates probable cause that drugs are inside the vehicle. The automobile exception activates.
And the scope of the automobile exception is vastly broader than SILA. Under SILA, we said cops can't search the trunk. But under the automobile exception, if they have probable cause drugs are in the car, they can search everywhere those drugs might be hidden.
The passenger compartment, the glove box, the trunk, and any locked bags inside the trunk. They can basically tear the car apart without a warrant.
Which brings up a very specific limitation that is heavily tested: Arkansas v. Sanders and the container rule. The scope of a warrantless search based on probable cause is defined by the object of the search and the places in which there is probable cause to believe it may be found.
Make that real for me.
Suppose the police receive a highly reliable tip. The informant says, "I just saw John put a stolen Rolex watch into a small brown leather briefcase. He locked it, put it in the trunk of his Honda Civic, and is driving north on Main Street."
The police spot the Civic and pull it over. They have probable cause that contraband, the stolen Rolex, is inside the car, so the automobile exception triggers.
Yes. They can open the trunk and seize the briefcase, and because they have probable cause the watch is inside it, they can force the briefcase open without a warrant. But, and this is the crucial limitation, their probable cause was specifically limited to that single briefcase.
Once they have the briefcase, can they go search the glove compartment of the Civic?
No, because they have absolutely no reason to believe the watch is in the glove compartment. The informant specifically said it was in the briefcase. Their probable cause doesn't bleed over to the rest of the vehicle.
Contrast that with the marijuana smell example.
Sure.
If the officer smells marijuana generally coming from the car, the drugs could be hidden anywhere, under a seat, inside a backpack, or in the trunk. Therefore, they can search all of those places.
The nature of the probable cause dictates the scope of the search.
So logical when you break it down. Let's move from hidden things to visible things. The plain view doctrine. This seems incredibly intuitive. If a criminal leaves their contraband sitting out on the kitchen table, the cops can seize it.
It is intuitive, but the doctrine, defined in Horton v. California, has 3 strict requirements you must check off. Number 1. The officer must be lawfully present at the place where the evidence can be plainly viewed.
Lawful presence. So if an officer illegally kicks down your front door without a warrant and sees cocaine on the coffee table, they can't claim plain view. The viewing itself was the result of a constitutional violation.
Correct. But if the officer is inside executing a valid warrant for stolen televisions and they happen to see the cocaine, their presence is lawful. Requirement number 2. The officer must have a lawful right of access to the object itself.
This is a tricky distinction. Let's say an officer is walking down a public sidewalk. They look through the front window of a house and see a massive marijuana plant growing in the living room.
The officer is lawfully present on the public sidewalk. The plant is in plain view. Can the officer immediately kick the front door down and seize the plant?
No. Seeing the plant through the window gives the officer absolute probable cause. But it does not give them a lawful right of access to bypass the physical walls of the home. They still need a warrant or an exigent circumstance to cross the threshold.
Plain view is not an independent exception to the warrant requirement for entering a home. It just allows cops to seize things once they are already lawfully inside. Requirement number 3. The incriminating character of the object must be immediately apparent.
This is where we bring in Arizona v. Hicks. The police entered an apartment under exigent circumstances. Someone fired a bullet through the floor into the apartment below. While searching for the shooter, an officer noticed 2 sets of very expensive stereo equipment.
The apartment was otherwise squalid, so the officer suspected the stereos were stolen.
But just looking at a nice stereo doesn't prove it's stolen. It's not inherently illegal like a bag of cocaine.
Exactly. To confirm his suspicion, the officer physically picked up the turntable, turned it around, and wrote down the serial number on the back to call it in. The number confirmed it was stolen.
But the Supreme Court said that was an illegal search. Why?
Because the incriminating nature of the stereo was not immediately apparent. The officer only had reasonable suspicion, not probable cause, when he first looked at it. By physically moving the equipment to read the numbers, he conducted a new, distinct search unsupported by a warrant.
Moving the stereo even a fraction of an inch destroyed the plain view claim. The police must be able to recognize the item as contraband purely from their lawful vantage point without manipulating it.
Let's talk about the ultimate bypass code: consent. If you just invite the police into your home, you waive your Fourth Amendment protections. No warrants or probable cause required.
But the consent must be truly voluntary, evaluated under the totality of the circumstances. It cannot be the result of duress or coercion. And deception plays a huge role here. Let's look at Bumper v. North Carolina.
A classic case. The police showed up at an elderly woman's house and announced, "We have a search warrant to search your house." The woman, believing she had no choice, said, "Go ahead." They found a rifle used in a crime.
Later, the prosecutor couldn't produce a valid warrant. The state tried to argue, well, the warrant was defective, but it doesn't matter because she consented.
The Supreme Court rejected that immediately. When an officer claims authority to search under a warrant, they are essentially announcing the occupant has no right to resist. The homeowner isn't consenting, they are yielding to the color of law.
If the warrant turns out to be fake or invalid, the consent is entirely void because it was procured through deception regarding legal authority. But here's a detail that surprises a lot of people. Do the police have to inform you that you have the right to refuse a search?
We all know Miranda warnings. But is there a Fourth Amendment equivalent? No, there is not. In Schneckloff v. Bustamante, the court ruled that while knowledge of the right to refuse is a factor, police are absolutely under no obligation to inform a citizen of that right.
Ignorance of your rights does not automatically invalidate your consent. Now we enter the trickiest area of consent. Third-party consent. The roommate rule. What happens when multiple people share a living space?
The baseline rule from United States v. Matlock is that a third party who possesses common authority over the premises, meaning mutual use and joint access, can give valid consent to search common areas.
If you share an apartment, your roommate can let the police search the living room, kitchen, and shared bathroom. But they generally cannot consent to a search of your private, exclusively controlled bedroom.
That makes sense. But what happens when the roommates disagree? Let's say the police show up. Both roommates are standing in the doorway. Roommate A says, "Yes, come on in." Roommate B says, "Absolutely not, get a warrant." Who wins the tie?
The objector wins. This is the holding of Georgia v. Randolph. The Supreme Court rooted this in widely shared social expectations. If a caller is standing at the door and one tenant invites them in, but the other explicitly tells them to stay out, a polite caller wouldn't enter.
The police are held to that same standard. If a physically present co-tenant expressly objects, the consent of the other tenant is invalid as to the objector.
Okay, so the police are stuck at the door. But let's look at the follow-up case, Fernandez v. California, because this feels like a massive loophole for law enforcement.
In Fernandez, police arrived at an apartment suspecting a man of a violent robbery. The man was at the door, and his girlfriend was battered and bleeding behind him. The man vehemently objected to the police entering.
Based on Randolph, his objection barred a consent search. But the police had probable cause to arrest him for domestic violence. So they lawfully arrested him, handcuffed him, and took him to the police station.
And once he was gone, they went back to the apartment, knocked, and asked the girlfriend for consent to search. And she said yes.
And she led them to the evidence of the robbery. Fernandez's lawyers argued that his initial no should still be valid even after he was removed, because the cops essentially manufactured the consent by arresting him to get him out of the way.
The dissent in Fernandez argued exactly that, but the majority disagreed. The majority held that the Randolph rule, that an objection overrides consent, is strictly limited to a co-tenant who is physically present.
Once Fernandez was lawfully arrested and removed, he was no longer physically present to object. At that point, the girlfriend had sole authority over the apartment.
As long as the police's removal of the objector is objectively reasonable and lawful-like a valid arrest, the remaining tenant's consent is valid.
That is a brutal technicality, but perfectly illustrates how the examiners will test the timeline of events. If the objector's in the doorway, no search. If the objector's lawfully placed in a squad car and driven away, the remaining roommate can open the door.
And one final note on third-party consent. Do not let the examiners confuse ownership with the expectation of privacy. A landlord owns the apartment building, but they have relinquished the expectation of privacy to the tenant.
A landlord absolutely cannot consent to a police search of a tenant's apartment. That's Chapman v. U.S. Similarly, a hotel clerk cannot consent to a search of a guest's room until the guest is checked out.
The bouncer protects the privacy of the occupant, not the owner of the brick and mortar.
All right. We are stepping out of the traditional criminal law enforcement arena and entering the world of the regulatory state, administrative and special needs searches. Up until now, we've been talking about police officers looking for evidence of a crime to put someone in jail.
But the government has other interests, right? Health inspectors, school principals, border patrol agents. When the primary purpose for a search is not ordinary criminal law enforcement, but a broader administrative goal, the strict probable cause and warrant requirements are often relaxed.
We evaluate these under a special needs doctrine, balancing the individual's privacy interest against the government's programmatic need. Let's run through some common MBE examples. The border.
When you enter the United States, customs agents do not need a warrant or even reasonable suspicion to search your luggage. The government's interest in protecting the national border outweighs the temporary intrusion on your luggage.
What about businesses?
Certain businesses are considered closely regulated industries. Think liquor stores, gun dealerships, or automobile junkyards. Because these industries are so heavily regulated, the owners have a significantly reduced expectation of privacy.
The government can conduct warrantless, unannounced administrative inspections to ensure compliance with licensing and safety regulations. And what about public schools? This is a huge area of litigation.
The landmark case is New Jersey v. TLO. A high school teacher caught a student smoking in the bathroom. The principal searched the student's purse and found marijuana and a list of people owing her money.
The Supreme Court held that the warrant requirement is entirely unsuited to the school environment. To maintain order, school officials do not need probable cause to search a student. They only need reasonable grounds to believe the search will turn up evidence of a violation.
The court took that a step further with drug testing in Vernonia School District v. Acton and Board of Education v. Earls. The court upheld random, suspicionless drug testing for students participating in extracurricular activities and sports.
The rationale is that students in a public school inherently have a lesser expectation of privacy. The school's interest in deterring drug use outweighs the minimal intrusion of a urine test.
But here is the critical limitation on all these administrative searches. The government cannot use an administrative rule as a Trojan horse for a criminal investigation.
If a detective suspects a homeowner is cooking meth, they cannot call up the local housing inspector and say, hey, go do a random fire code inspection of this house so you can snoop around for meth lab equipment for me.
Correct. If the primary programmatic purpose of the search is actually criminal investigation, the administrative exception vanishes and the police need a standard warrant.
However, if an administrative search is genuinely valid, say a health inspector is conducting a routine inspection of a restaurant kitchen, they open a flour bin and find a brick of cocaine, that evidence is admissible under the plain view doctrine.
Let's pivot to a completely different type of search. The interception of conversations. Wiretapping and eavesdropping.
I want to pose a scenario. I am sitting in a crowded coffee shop. I lean over a small table and I whisper to my best friend, confessing to a massive corporate fraud scheme. I think I am completely safe.
But unbeknownst to you, your best friend has turned on you and is wearing a hidden microphone, transmitting your entire conversation to an FBI van parked across the street. Did the government violate your Fourth Amendment rights by recording you without a warrant?
They absolutely did not. This falls under the false friend doctrine, articulated in United States v. White. The Supreme Court has consistently held that the Fourth Amendment does not protect a wrongdoer's misplaced belief that a confidant will not reveal their secrets.
So, assumption of risk. When you open your mouth and speak to another human being, you assume the risk that they might be an undercover officer or wearing a wire, or that they might simply walk into a police station tomorrow and repeat everything you said.
You have no constitutional expectation of privacy in the trustworthiness of your companions, and this ties back to the fundamental test of the Fourth Amendment from Katz v. United States.
The Fourth Amendment protects people, not places. But it only protects what you seek to preserve as private. In Katz, the FBI attached an electronic listening device to the outside of a public telephone booth to record Katz making illegal gambling bets.
And the court ruled that even though Katz was in a public place, by stepping into the booth and shutting the glass door behind him, he exhibited a subjective expectation of privacy that society was prepared to recognize as reasonable.
The FBI's warrantless wiretap of the booth violated the Fourth Amendment, which highlights the difference between the coffee shop scenario and a formal wiretap.
If the government uses an informant wearing a wire, no warrant is needed because of the assumption of risk. But if the government wants to intercept your phone calls directly or bug your office without anyone inside knowing, they are bypassing human interaction entirely.
And for that, they need a Title III wiretap warrant, which is significantly more difficult to obtain than a standard search warrant. A wiretap is essentially a continuous, ongoing search of every word spoken over a line.
To prevent it from becoming a limitless dragnet, a wiretap warrant must meet rigorous criteria. It must demonstrate probable cause of a specific crime. It must name the specific persons expected to be overheard.
It must describe with particularity the types of conversations expected to be intercepted. It must be strictly limited in duration, typically 30 days, and crucially, it must include provisions for minimization.
Meaning the agents must stop listening if the conversation turns to innocent, non-criminal matters. The bar examiners frequently test the conceptual difference between a direct, unconsented wiretap, which requires a strict warrant, and a conversation recorded by a cooperating informant, which requires no warrant at all.
Which brings us to our final act, the remedy. We have spent this entire deep dive establishing the intricate rules the police must follow to get past the bouncer.
But what happens when the police just ignore the velvet rope? They break into a house without a warrant, without an exception, and they find the murder weapon. How does the legal system respond?
The response is governed by the exclusionary rule, but before a defendant can even invoke that rule, they must cross a threshold barrier known as standing. You cannot suppress evidence simply because the police behaved badly.
You can only suppress evidence if the police violated your personal Fourth Amendment rights. So if the police illegally break down my neighbor's front door, rummage through their living room, and find a bloody knife that I hid there, I cannot complain about the illegal search.
Precisely. You did not have a legitimate expectation of privacy in your neighbor's living room. The police may have violated the neighbor's rights, but they did not violate your rights.
Therefore, you lack standing to challenge the search, and the prosecutor can use the bloody knife against you at your murder trial.
Let's say the police illegally search the trunk of my car and find a duffel bag full of drugs. To prove I have standing, I have to go to a pre-trial suppression hearing and testify to the judge, yes, that is my car, and that is my duffel bag.
But wait, if I admit under oath that I own the duffel bag full of drugs, won't the prosecutor just hand that transcript to the jury at my actual trial to prove I'm guilty?
That is a classic catch-22, and the Supreme Court recognized how unfair it would be to force a defendant to surrender their Fifth Amendment right against self-incrimination in order to assert their Fourth Amendment right.
Therefore, the rule from Simmons v. United States dictates that testimony given by a defendant at a suppression hearing strictly to establish standing cannot be admitted as substantive evidence of guilt at the actual trial.
Okay, so you establish standing. You prove the search was unconstitutional. Now the hammer falls, the exclusionary rule kicks in.
First articulated forcefully in Weeks v. United States and later applied to the states in Mapp v. Ohio, the exclusionary rule mandates that evidence obtained in violation of the Fourth Amendment cannot be introduced by the prosecution at the criminal trial to prove the defendant's guilt.
And it goes further than just the primary physical item seized. We have to talk about the greatest metaphorical name in all of constitutional law, the fruit of the poisonous tree doctrine, from Wong Sun v. United States.
The doctrine states that the exclusionary rule applies not just to the primary evidence found during the illegal search, the poisonous tree, but also to any secondary evidence that is derived from or discovered as a direct result of that initial illegality.
The poisoned fruit. The outline provides a perfect illustration. A police officer conducts an unconstitutional, warrantless search of your home. While illegally digging through your desk, they find a small black address book. That book is the poisonous tree.
They open the book, find the name and address of a witness to your crime, go interview that witness, and get a confession. The witness's testimony is the poisoned fruit. Because the police only found the witness by tracing the roots of their initial misconduct, the witness's testimony is suppressed.
However, the courts possess a deep institutional reluctance to let clearly guilty people go free simply because a police officer made an error. The truth-seeking function of a trial is heavily compromised when reliable evidence is hidden.
Therefore, over the decades, the Supreme Court has carved out several massive loopholes, exceptions to the exclusionary rule that prosecutors use to save the evidence. Let's run through these prosecutor lifelines. The first is inevitable discovery.
The landmark case here is Nix v. Williams. The police violated a suspect's rights to get him to reveal where he had hidden a victim's body. However, the prosecutor proved that at the exact moment the suspect confessed, a massive search grid of hundreds of volunteers was already sweeping the woods just a couple of miles away and moving directly toward the body.
The Supreme Court held that if the prosecution can establish by a preponderance of the evidence that the information ultimately or inevitably would have been discovered by lawful means, the evidence is admissible.
The second lifeline is the independent source doctrine. Imagine two entirely separate teams of detectives working the same case. Team A illegally breaks into a warehouse and sees crates of stolen weapons. They leave and say nothing.
Meanwhile, Team B, completely unaware of Team A's illegal break-in, goes to a magistrate with a mountain of lawfully obtained evidence, gets a valid search warrant for the warehouse, and seizes the weapons.
Because the lawful seizure by Team B was genuinely independent of Team A's illegal conduct, the evidence is not poisoned, it comes in.
The third lifeline is the most complex for the MBE, attenuation of the taint. This means the chain of causation between the initial police misconduct and the ultimate discovery of the evidence has been stretched out so far, or interrupted by so many intervening events, that the taint of the original illegality is purged.
The best modern example of this is Utah v. Strieff. An officer staked out a suspected drug house. He saw Strieff leave the house, and without any reasonable suspicion, the officer stopped Strieff on the street. This was an unequivocally illegal, unconstitutional Terry stop.
During this illegal stop, the officer asked for Strieff's ID and ran a routine background check with dispatch. And the background check revealed that Strieff had a pre-existing valid arrest warrant for an unpaid traffic ticket.
So, the officer arrested Strieff on the valid warrant. And incident to that lawful arrest, the officer searched Strieff's pockets and found methamphetamine. Strieff argued the drugs should be suppressed because the initial stop was completely illegal.
If the officer hadn't made the illegal stop, he never would have found the warrant and never would have found the drugs.
But the Supreme Court ruled the drugs were admissible. They held that the discovery of a valid, pre-existing, and untainted arrest warrant was a massive intervening circumstance. It broke the causal chain. The drugs were found as a result of the lawful arrest warrant, not the initial illegal stop. The taint was attenuated.
This brings us to the final and arguably most important exception to the exclusionary rule. The good faith exception, solidified in United States v. Leon and Herring v. United States. To understand this exception, you must fundamentally understand why the exclusionary rule exists.
The Supreme Court has repeatedly stressed that the exclusionary rule is not a personal constitutional right of the aggrieved party. It doesn't exist to compensate the victim of an illegal search. Its sole purpose is to deter future police misconduct. It's a punishment designed to make the police behave better next time.
Exactly. So, what happens when a police officer isn't behaving badly? What happens when an officer does everything right, acts in objective good faith, but a mistake is made by someone else?
In Herring, a police officer arrested a man based on a computer database showing an active arrest warrant in a neighboring county. The officer searched the man incident to arrest and found drugs and a gun.
10 minutes later, the neighboring county called back and said, "We made a mistake. That warrant was recalled 5 months ago. The database operator forgot to update the system." So the arrest was illegal and the search was unconstitutional because there was no actual warrant.
But the Supreme Court refused to suppress the drugs. The court reasoned that the arresting officer on the street did nothing wrong. He reasonably relied on the computer system. The error was the result of isolated negligence by a clerk.
Throwing out the evidence wouldn't deter the arresting officer from doing anything differently in the future. The court concluded that the exclusionary rule should only apply when police conduct is deliberate, reckless, or grossly negligent. Isolated, good faith mistakes do not trigger suppression.
So if I'm taking the bar exam, when doesn't the good faith exception save the evidence? Good faith will not apply if the officer actively misled the magistrate by lying in the affidavit, the Franks rule.
It will not apply if the warrant is so facially deficient, like failing to specify what to search for, that no reasonable officer could presume it to be valid. And it will not apply if the magistrate wholly abandoned their judicial role and essentially became a rubber stamp for the police.
To wrap up our comprehensive analysis, the outline concludes with a concept that overrides almost everything we've discussed. We've talked about exceptions, good faith, and warrants. But there is a line the government simply cannot cross, regardless of how much probable cause they have.
Evidence obtained by methods that shock the conscience is strictly inadmissible. This doctrine protects the absolute sanctity of the human body against severe intrusions. The Supreme Court has drawn a line based on the severity of the physical violation.
For example, in Maryland v. King, the court allowed the police to forcefully swab the inside of an arrestee's cheek to collect a DNA sample. The court viewed a buccal swab as a quick, painless procedure that barely involves an intrusion beneath the skin. It's akin to taking a fingerprint.
But contrast that with the shocking facts of Winston v. Lee. A shopkeeper shot an armed robber in the chest during a holdup. The suspect fled but was found nearby with a bullet lodged near his collarbone.
The prosecution wanted that bullet to definitively match it to the shopkeeper's gun. They had absolute ironclad probable cause. They had a court order. They wanted to strap the suspect to a gurney, put him under general anesthesia, and have a surgeon cut into his chest to remove the bullet.
And the Supreme Court said absolutely not. Forcing a citizen to undergo major invasive surgery against their will simply to obtain evidence is a massive violation of personal privacy and bodily integrity. It offends a sense of justice.
It shocks the conscience. Even with a warrant, the Fourth Amendment forbids it. And that perfectly encapsulates the delicate, constant balancing act of the Fourth Amendment.
Yeah.
The needs of law enforcement to solve crimes weighed against the profound right of the individual to be secure in their person, houses, papers, and effects.
We have covered an immense amount of ground today. We traced the strict requirements of warrants, the chaotic realities of warrantless street encounters, the complex rules governing vehicles, the regulatory state, and the intricate loopholes of the exclusionary rule.
If you are studying for the MBE, remember to look past the surface of the facts. Ask yourself, what is the justification for the search? What is the scope? And what is the underlying purpose of the remedy?
Before we sign off, I want to leave you with a final provocative thought that builds on everything we've discussed. We have spent the last hour meticulously analyzing physical spaces, doors being kicked down, pockets being padded, trunks being opened. But the nature of a search is fundamentally changing.
The VIP Club is going digital. Consider the trajectory of technology. We are entering an era of smart homes, ubiquitous sensors, and biometric data.
Imagine a scenario where the police suspect you of manufacturing illegal drugs in your home. They don't want to get a warrant. So they park an unmarked van down the street. Inside the van is a device that analyzes the ambient Wi-Fi signals that are naturally radiating out of your house.
By measuring the minute disruptions in those invisible radio waves, a sophisticated algorithm can map the interior walls of your home and track your physical movements from room to room in real time. They never cross your property line, they never touch a physical door, they never even aim a camera at a window.
How do the courts apply an 18th century constitutional amendment written by men in powdered wigs worrying about physical trespass to a 21st century invisible search? Is the interception of a bouncing Wi-Fi signal a seizure?
Does the bouncer at the Velvet Rope even know how to look for radio waves? The Supreme Court grappled with primitive thermal imaging in Kilo v. United States, but as technology outpaces the law, the definition of a search will be the next great frontier of constitutional litigation.
That is a fascinating, slightly terrifying thought to ponder as you continue your studies. Thank you so much for joining us on this deep dive into the Fourth Amendment. We know the material is dense, but you now have the conceptual framework to dissect any fact pattern they throw at you. We wish you the absolute best of luck on your learning journey, and especially on the MBE. You're going to crush it. Until next time.